If your contractor agreements say work made for hire, you might not actually own your product, and that will kill your funding round. Let me explain why. All right, so here's a scenario. You're a non-technical founder, so you hire a developer to build your MVP and you pay them as a contractor. 1099, not W-2. Work gets done, you pay the invoice, and you own the code now, right? Not necessarily, and this is where most founders make a really expensive mistake. So the thing is, most contractor agreements I see have language like this. All work products shall be considered work made for hire under U.S. copyright law. And founders think that this means that they own everything that the contractor creates, but here's the problem. Work made for hire only applies to employees and not to contractors and not to freelancers. Under the U.S. Copyright Act, for something to qualify as a work made for hire with a contractor, it has to fit into one of 9 very specific categories, like a contribution to a collective work or a translation. Your software, your app, your website generally does not fit into any of those categories. So legally, that phrase pretty much does nothing for you. The contractor still owns the copyright and you just have an implied license to use it, which means that you cannot sell your company without them signing a release. You can't stop them from reusing that code for someone else. And when investors do their due diligence, they're going to find this and either they're going to kill the deal or they're going to force you to chase down every contractor that you've ever worked with in order to get retroactive assignments. And I've seen this delay funding rounds by months. So, what should your contractor agreement actually say instead? You need to use present tense assignment of intellectual property. Something like contractor hereby assigns the company all right, title, and interest in any work product created under this agreement, including all intellectual property rights therein. See the difference? Work made for hire is trying to claim a status that doesn't actually apply. Hereby assigns is an actual transfer of ownership. This is a present transfer, meaning it happens the moment the contractor creates the work. You own it immediately. Clean cap table, fundable company. And here's the key. This works whether they're creating software, design work, marketing materials, whatever. The assignment language is flexible. The work made for hire language is not because it relies on the U.S. copyright code. Now, if you're watching this and you're thinking to yourself, oh no, I've already hired 5 contractors, my agreements say work made for hire, don't panic. You can fix this retroactively with what's called an assignment agreement. It's a short document where the contractor confirms that they're assigning all the rights to you. Is it better to have the right language up front in the original agreement? Yeah, of course it is. But can you clean this up after the fact? Also, yeah, of course you can. You just want to do it before you raise money, before investors will find this, and before the contractor feels like they have leverage on you. I put together a free contractor agreement checklist that walks through this issue and some other mistakes that I see founders make with contractor agreements. The link is in the description below, so grab it, use it, fix your agreements. And if this was helpful, subscribe, like. I'm breaking down contract mistakes like this all the time and the stuff that actually will kill your deals or cost you money, not the theoretical stuff that they teach you in law school. What contract topic do you think I should cover next? Service agreements, NDAs, equity splits? Drop it in the comments and I will see you in the next one.